Welcome to this History and Policy event, part of the Arts and Humanities Festival at King's College on marriage, civil partnerships and gay rights. And we envisage this as a discussion which is very much in keeping with the kind of work that History and Policy does, which provides a sort of bridge between historical research and issues of contemporary relevance. And it's great that we've got a nice variety of disciplines represented here to talk about these issues, ranging from politics across history and to law. I'm Lucy Delap, and I'm going to introduce the speakers. I have apologies from our third speaker, Robert Wintermute, who is going to come but has been delayed, so he'll be joining us at about 7. But we're going to get the discussion going with our first two speakers. Can I just remind you all before we start to turn off your mobiles, if you would, or turn them onto silent. You're very welcome to tweet from the event, but try to keep the noise down. I also wanted to give a heads up about a very interesting lecture which the Menzies Centre, the King's College London Centre looking at Australian history, are running on the 4th of November at 6:15. You're all most welcome to come. It's on marriage and women's same-sex relationships over the period 1945 to 1979. And that's going to be Rebecca Jennings, who's an Australian historian who works comparatively looking at Australia and the UK. So that's going to be November the 4th, 6:15 in the Virginia Woolf building, B5.22. But just look it up on the Menzies Centre website if you'd like to come. And let me encourage you all to join that conversation as well. Okay, so to our speakers, we have with us Kelly Coleman here on my left, who's a senior lecturer in politics at the University of Glasgow. She teaches comparative politics and international relations, and her work has really focused on how same-sex unions have diffused across Western democracies. So she's very much going to give us the contemporary perspective across these different national contexts. She's recently published a book called The Same-Sex Union's Revolution in Western Democracies, on which she'll be drawing. We're then going to hear from Julia Moses, who's a lecturer in modern history at the University of Sheffield. She's writing a book at the moment about marriage and the state in Imperial Germany, and that builds very much on her first book, which was titled The First Modern Risk: Workplace Accidents and the Making of European Welfare States. And finally, we're going to have Robert Wintermute, who's a professor of human rights law at King's College London. And he's the author of multiple studies on same-sex partnerships and homophobia. And he's also been very active in public interventions at the European Court of Human Rights, where he's been challenging the segregation of couples into same-sex partnerships and marriage according to their sexuality. So he's going to give us very much a practitioner's sense of where these debates are going. So welcome all, and I think we'll go to Kelly now for the first presentation.
Yeah, great. Okay, thank you, Julie, for the kind introduction, and thank you all for coming out on this evening. As Julie explained, I'm a political scientist, and I was asked here to kind of give an overview of what I think has been probably the most visible and prominent kind of change and policy change to family policy over the past 2 decades. And this draws on work that I've been doing for several years now on same-sex unions, and was finally published last year as a book under the title The Same-Sex Union's Revolution in Western Democracies. And I do realize that, that using the word revolution can be a bit controversial, particularly with historians in the room. I think they're always very skeptical of saying anything is radically new. And of course, indeed, I do agree with this, that you can't look at the history of marriage and not notice that it has changed quite a bit from decade to decade and from century to century. But I use the word revolution, one, because obviously I'm talking about a policy revolution, but also to highlight that I think this is it's not unprecedented change, but I do think it's significant change, that there's this change in family policy that's happened in Western democracies over the past 2 decades. It also can be a bit controversial to use the word revolution in terms of same-sex marriage or same-sex unions with feminists in the room, and I vaguely consider myself to be a feminist as well. And feminists often have had an issue with whether this looks like progressive change or not, given all the kind of historical baggage that marriage obviously brings with it, and some of the some of the problems that have been associated with that and the place of women in society. And again, I agree with that as well. That this has been, I think, a policy revolution, but it has been one that I think has been at least somewhat conservative in nature. And it doesn't have to be that way, and its future doesn't have to be that way. And I'll try to pick up on some of those points at the end of the talk as well. Showing myself to be the usual technology idiot here. Okay, here we go, back on track. If you look at this slide, this is kind of the state of same-sex unions. I'm going to say the world same-sex union-wise. I've been using this slide for about the better part of 5 years now, and it used to be that this was a much smaller list and a much smaller slide. I used to be able to use 16-point font on these different columns, and now in the registered partnership column, I think I'm down to 11-point font on that. So first, apologies for if it's difficult to read, but it does kind of highlight that there has been a lot of change over the past few years, in 2 decades in particular. And I think there's really 3 things to kind of note on this particular slide. And the first of these is that this policy change has happened over a relatively short period of time. I'm looking out there in the audience, I'm seeing a lot of young faces. So this may seem like a longer stretch of history to you than it does to me, but if you notice that the first of these national same-sex unions laws was passed in Denmark in 1989. And I was already in university in 1989, so to me this doesn't sound like a very long time ago at all, although I have to admit that it is becoming farther and farther away, 1989. But in terms of historic arcs, this is not a particularly long period of time over which a lot of policy change has happened, and a lot of countries have adopted these same-sex unions policies. So that's the first thing to note. The second thing to note is that not only is this clustered in time, these policy adoptions, it's clustered in region as well, right? That if you look at the countries up there, the vast majority of them are European countries. Now that's beginning to change, obviously. Obviously you have countries in North America, particularly Canada, that is, and increasingly Oceania, so Australia and New Zealand, and most recently Latin America. But ultimately, this is still quite a regional phenomenon, and one that very much started largely in Europe, right? And the third thing to note on this slide is that in the last 5 years or so, certainly since 2005, what we've seen here is really a marriage boom. That is that it used to be the most prevalent way to recognize same-sex couples by the state was through something called the registered partnership, which took slightly different forms in different countries, obviously civil partnerships in the United Kingdom. But that has really changed, and changed dramatically since 2009. That is, there's very few countries after 2009 that have, if they've gone to same-sex unions, that have not implemented a marriage policy. And many countries, as the UK of course did, added marriage on, or opening of marriage to same-sex couples onto a registered partnership, right? So that we've really kind of changed the focus of, and the model used to recognize same-sex couples since 2009. And these other ways of doing it, unregistered cohabitation or domestic partnership as that's sometimes called, or registered partnerships, that those have kind of fallen out of favor since in the last 5 years or so. And all of this, and this is kind of what I try to argue in my work on this issue, I think goes to show that that these things are not coincidental, right? Of course, there are things going on in these Western countries, much more permissive sexuality and sexual culture, much less homophobia than used to be there, say, 3 or 4 decades ago. Of course, that's important to this story, right? But the other thing that's important to it is the types of international influences that have helped propel this cascade or this kind of spread of these same-sex unions. That is that I would argue that you cannot understand LGBT politics, and you definitely cannot understand same-sex unions by domestic politics alone. That you have to look at the international context in which this policy change has happened. Let's see. There we go. In particular, what I argue, or have argued, is that the European polity has played a really important role in catalyzing this policy change. And by European polity, I don't just mean the European Union, or the European Court of Human Rights, which I'm sure Robert will talk a great deal about in his remarks. But I mean also, and perhaps in this case more importantly, the informal policy networks and also activist networks that crisscross the European polity and have really helped to build what is largely a non-binding, that is, it's not a legal mandate, but a non-binding norm for same-sex relationship recognition by states, right? And they particularly defined the state recognition of same-sex couples as a human right, right? And a human right that liberal democracies should not deny to same-sex couples simply because of their sexual orientation. It has been the strength of that argument, rather than international mandates or legal mandates, of which there are still very, very few, even in the European human rights regime. It has been the strength of that human rights argument that has helped spread, and the example of other countries that has helped kind of spread this spread of these policies, of same-sex unions policies. As you see there, I think this has been a great European success story, not just because there's been a lot of the policies helped catalyze policy change, but also because in doing so, it has helped raise the reputation that Europe has as a normative power, or as a kind of human rights kind of vanguard. And they often will use European, both state officials, but also EU officials, will often use LGBT rights and the expansion of LGBT rights as being something that Europe has very much promoted globally, right? And so this, as I said, has been kind of seen as a European success story. Here I try to kind of to represent this argument graphically. And this is what policy diffusion scholars often call an S-curve. And what it represents, so what you see there, the blue line, I hope it looks blue, I think it does. The blue line represents how many countries, and by countries I'm just looking at Western democracies of Western Europe and North America at this point in this particular slide. And the blue line represents how many countries in that year actually had a national same-sex unions policy on the books. And what you can see, and the reason why it is an S-curve, is what that represents is that there was the clustering in time of when most of these policy adoptions happened, right? And you can see, so you get that steep kind of curve up, and then it flattens out at the end as time goes on, right at the end of the horizontal bar there. And that is because eventually what happens in policy diffusion is that it becomes saturated. Most countries eventually will have adopted a particular policy, and therefore the rates of adoption kind of tail off at the end there. And that's what's happened, not globally yet, but that's what's happened in Western Europe and in Western democracies so far. So that follows kind of a classic pattern of policy diffusion, where you see lots of very clustered adoptions of a single type of policy. And the argument is that if this was just happening through random domestic events, probably you wouldn't see that compression in time, right? You wouldn't see that sharp uptake in the middle of the graph there and then the tailing off at the end. So then the other thing, the horizontal bars then are kind of, I won't go into the details of what these decisions were, what these policy decisions were, but essentially they were decisions that were taken either by the EU or the European Court of Human Rights that expanded LGBT rights, not necessarily relationship recognition. Again, there's very few international legal mandates for same-sex relationship recognition, but it expanded the idea that LGBT rights are human rights and that sexual orientation discrimination was no longer permissible in liberal democracies, right? And you can see that as these decisions were made, that you do see kind of a spike in kind of the uptake of these types of policies. Now, the causation there obviously is much more kind of complex than that, but you can see kind of a relationship of the incorporation of sexual orientation into the European human rights regime and the uptake of the adoption of these particular policies. So that's how a political scientist would try to explain the European influence on this policy area. This is how an activist did. And as usual, the activist is much more eloquent than the political scientist, which isn't always that difficult. This is a quote from Manfred Bruns, who was one of the leading campaigners for same-sex unions and same-sex marriage in Germany in the late 1990s and early 2000s. And he had been around for a very long time in the movement. And what he said was, in the public, there was no discussion of the so-called homo marriage until the implementation of the Danish Registered Partnership Law on October 1st, 1989. It was only after seeing pictures of male and female couples registering in the marriage hall of the city chambers in Copenhagen did it gain attention and begin to occupy people's imaginations, right? And so he shows kind of the powerful effect that, seeing what was going on in other countries had on the movement in his own country, which was Germany. What is quite interesting about this quote is not only that he mentions how influential that first country, Denmark, was in 1989, but this quote here does actually have certain flights of imagination in it itself, because in fact what was happening on October 1st, 1989 in Denmark was not marriage, it was a registered partnership, right? But you can see that, that marriage becomes very important in this. The other thing that's not correct about this quote is that he says what you could see were female and male couples being registered. In fact, you couldn't. There were only male, on that first day, there were only males who showed up to have their partnerships recognized by the state. That women in 1989 in Denmark, or women activists in particular, were quite skeptical of this reform. They'd come out of the feminist movement, many of them, and again did not really see the opening of marriage or marriage-like ceremonies as being particularly progressive. And they didn't show up. It was only the men that did, right? And I think what this highlights, those two kind of mismemories, I guess, of Manfred Bruns, is how important symbolism and the nature of symbolic politics has been to this policy diffusion and the diffusion of same-sex unions. And that is what I think does make it a really interesting case of policy diffusion. You know, lots of policies diffuse across European countries. It's not particularly new. Tax policy does, you know, accounting standards do as well. But very few of them have had this idea of symbolic politics being so much a part of it and having the public be so much a part of it as same-sex unions. And indeed, the learning curve, I would argue, this international learning curve that we have around same-sex unions very much is driven, not exclusively. Human rights norms always have a lot of resonance, but so does marriage. A lot of these Northwestern European countries, I think, thought that they were kind of post-marriage societies and kind of beyond marriage. And so that it was quite surprising, I think, to a lot of people how much symbolic resonance marriage or even marriage-like registered partnerships still had in these countries. And this kind of brings up a point that Cheshire Calhoun, who's a feminist political theorist in the US, wrote in about 2000, so before the first marriage law actually happened in the Netherlands. And she argued, I think at the time it was kind of against a lot of feminist thinking, argued that actually not being able to marry, right, not being able to participate in civil marriage in particular, was really at the heart of Western homophobic ideologies. That a lot of feminist scholarship had thought of kind of homophobia and misogyny as being kind of on the same register, kind of having the same roots. And what she argued, she wasn't arguing that you know, there wasn't misogyny. She was just arguing that these are actually quite different things. Homophobia had its own set of ideologies around it. And she thought at the heart of this was actually the fact that you couldn't be recognized by the state, probably more importantly by society, as being able to form a family. If you couldn't do that, you lost a lot of social legitimacy. And so she is one of the few, certainly not the only, but one of the few feminist scholars who very early came out for same-sex marriage and the opening of marriage to same-sex couples, exactly because she thought it would get at the heart. She wasn't a huge fan of marriage, actually, but she thought it would get at the heart of the oppression of gays and lesbians. And everything that's happened since 2000 has really kind of reinforced her point, I think. And it is therefore perhaps not surprising that LGBT rights movements have really gone a long way to portray non-marriage registered partnerships as being marriage-like. Right? So Manfred Bruns called registered partnership in Denmark homo marriage, right? Or homo as it's said in Germany. And I think this photo, which is a little bit dark, unfortunately, on screen, I think actually really does kind of highlight how much LGBT groups have really kind of highlighted and tried to draw on the symbolism of marriage to make the most of this reform and help it to bring kind of societal change. This is a picture of Axel and Eigil Axgil on October 1st, 1989 in Copenhagen. They were the first couple to have their, first same-sex couple, I should say, to have their partnership recognized by a modern state. That is the first of these 11 Danish male couples to have their partnership registered. And what you can see there, hopefully, I think, in that picture is that they really did try their best to make this look like a marriage. They're in traditional marriage attire. They've got a boutonniere. You maybe can just barely see that there's a champagne glass there. They arrived into the city chambers in Copenhagen, and you can't quite see the horses there, but that is a horse-drawn carriage. Right? They did everything they could to kind of push the traditional marriage buttons to make it look like this was kind of the opening of marriage to same-sex couples. Of course, it wasn't exactly. It was a registered partnership that did not have all the rights and benefits associated with marriage attached to it. But it does seem to have been quite effective, right? You can see there are a lot of people there. And you can hopefully just kind of make out that there's also a huge, one of those boom kind of microphones. Obviously, there was probably a television camera man associated with that as well. That is, the international media did turn out in pretty good numbers for these first sort of gay weddings. And you saw pictures like this kind of going around the world. So that Axel and Eigil Axgil did become quite famous for being the first couple to have their partnership recognized by a state. And again, they seem to be very, very aware of the importance of the symbolic power that marriage has had. And I think another kind of point that helps underline how important symbolic politics has been to same-sex unions and their spread is that before 2000, before the year 2000, I think this is right. Every single country that adopted a same-sex unions policy had an anti-discrimination policy, had passed and adopted and implemented an anti-discrimination policy that had sexual orientation in it. I banned sexual orientation discrimination in the workplace. After 2000, not all of the countries that adopted a same-sex unions, but a significant number of them actually adopted same-sex unions first, before they went to the anti-discrimination legislation. And it had always been considered by legal scholars and activists that there was a natural progression. You decriminalize homosexual behavior first, you equalize the ages of consent, you do anti-discrimination policy, and then you get family policy, you get same-sex unions. And that has been tipped on its head a little bit since 2000, as countries and activists in different countries see the incredible symbolic and social legitimacy that seems to come with same-sex unions. This has brought, of course, these movements, as I said, great gains, right? On the other hand, I think it has, to a certain extent, perhaps limited or at least created sort of a missed opportunity for this family policy reform. That when you look back in history and you look at the Nordic countries, which were the first to implement these same-sex unions, and the idea of registered partnership had been around since about the 1960s and the 1970s in these Nordic countries. But it had come and been created not as a way to recognize lesbian and gay couples, but as a way to recognize a plurality of different types of families, right? And so included in this was polygamous relationships, communal living where you had multiple adults who were raising different kids. And the gays, you know, and lesbians at that point were just kind of a side thought to bring into this registered partnership. Now, all of that kind of went by the wayside when this idea gets brought back again in the late 1980s and early 1990s. And the only thing then that is there are the same-sex couples, right, for these registered partnerships. And it became a way of, you know, as a political compromise, because states at that time were probably just not ready to open marriage to them, right? But what happens, though, is that that all of that kind of pluralization, which was part of the original goal of changing family policy, kind of gets lost. And LGBT rights groups, because of the symbolic power of marriage, had every incentive to make these registered partnerships look like marriage, because that's what brought greater social tolerance to gay and lesbian couples and gay and lesbian individuals, right? Even people who weren't particularly interested in participating in these things. But it has been the case that because of this emphasis on marriage and making registered partnerships look so much like marriage and pushing on the buttons of all the symbolism and traditionalism of marriage, it has kind of limited the nature of the same-sex unions revolution and the family policy change that has kind of happened in its wake. So I think I'll end by just saying that there is an ongoing sort of debate in the UK, and I think Robert will pick up on this, because I know he's been involved in some of the activism of this, as Lucy, as she alluded to. That is that there is still a debate going on that now that same-sex marriage or marriage has been open to same-sex couples, should we actually also kind of extend civil partnerships to those different sex couples who aren't particularly interested in the traditional type of marriage that is only on offer to them right now. And so if that could be the case, right, if we were to extend civil partnerships to different sex couples in the UK, it could be a way of kind of recovering what I think is a bit of a missed opportunity in order to try to pluralize family policy and get the state to recognize and put legitimacy on different types of families. So I'll leave it there.
Thank you very much, Kelly. And on that note of talking about the pluralization of families, we'll get a perspective now from Julia, which very much picks up on the historical resonances of that. Julia Moses.
So thanks very much for that, Lucy. I'm going to talk a little bit about the history of family policy. And I'm a modern Europeanist, and I've been working, in particular, as Lucy mentioned earlier on a project which I'm very grateful for AHRC support on marriage and the state in Imperial Germany. And probably most of you in this room are wondering, why should I care about marriage and the state in Imperial Germany? What is Imperial Germany? Where is it? When is it? What's going on? It's 1871 to 1918. And I think this is a really interesting starting point for thinking about debates about the family and thinking about marriage, because Imperial Germany is a new country, pops up on the map out of the blue. 4 years after it's created in 1871, it creates a national marriage policy. And so you may be wondering, this is kind of interesting. Why is a new country, which has a lot to do, it has to create roads and taxes and all sorts of boring things that new countries do, why does it create this new marriage policy right out of the blue? And it unrolls this policy across the country. So this is a really interesting question, and it got me thinking, why do countries actually regulate the family in the way they do? And why do they focus on marriage in particular? And like Kelly, I think that we have to look at the symbolic level, that marriage is often seen in the past, as it is in very recent debates, as a symbolic heart of the family. And so it's gotten a lot of political coverage and certainly legal coverage, which is why we could see already in the 1870s that in this case in Imperial Germany, there's a real strong focus on marriage as a way to create a new country. So what I'm interested in doing today is thinking about this big question about how do states get involved in the family, and what does this mean for us today? So obviously we can look way back at the past, we can look at Germany and think, okay, that's interesting, but what I'd like to argue today is that what Germany is doing in the late 19th century actually has a really strong impact on how we think about marriage and family today. And in particular, what I'd like to encourage everybody in the room to think about is that the family we may think of as something which is ongoing and stalwart, and that marriage in particular has been something which is unchanging over time. But if we look back in the past, we can actually see that states have often tinkered with marriage, just like churches have often tinkered with marriage and with the family. And that this isn't necessarily an institution which is long-lasting and without innovation. So thinking about this very far back example over 100 years ago, how do we go forward in time? How do we go forward to what Kelly was just talking about, and how do we go forward to very recent discussions in the UK? And I think that there are a number of different points of connection that are relevant for us. So just thinking back a couple of months to early June, sort of late May, there was a really big debate in the UK about forced marriage that many of you probably heard about, maybe some of you saw in the newspaper. There was a big discussion about it because a new law was instituted. So Circular 01-2014, new forced marriage offenses. Not a very exciting law code name, but it was actually quite interesting because what it meant was that people who were involved in forcing others into marriage, usually young women, could be imprisoned for up to 7 years. So this is a time where we see that marriage, like in 1870s Germany, comes to the forefront of national policymaking. And this is really interesting. Why is this happening? So on the one hand, we can see maybe it's happening because there are a lot of documented cases. So just last year, there were 1,302 documented cases of forced marriage in the UK, usually involving young women. So there is a public outcry and a public discussion about it. But part of the reason why that there was this public outcry and public discussion was because forced marriage seemed to go against what the current government thought was correct. So Theresa May, the Home Secretary, who was in charge when this new circular came about in June, said that forced marriage just didn't coincide with UK standards of living. It just didn't seem to mesh with how things work here. And it in particular didn't seem to mesh because it went against the freedom to choose how to get married. And this coincides exactly with what Kelly was talking about. The emphasis on freedom to choose what kind of marriage or what kind of living situation you want to be in, whether you want a civil partnership or whether you want to cohabit or whether you want to get into a same-sex marriage, this is coming to the forefront. And forced marriage seemed to go exactly in the opposite direction. It didn't seem to work. So we see that there's some sort of UK efforts. For example, here's a great picture from the West Midlands Police in Birmingham of an initiative at Birmingham Airport to combat forced marriage. And there's a really strong police initiative and certainly this legal initiative. So why is this? Well, I think that this is coming to the forefront in part because of exactly what Kelly was talking about. The freedom to choose is coming to the public consciousness more than ever before in terms of public debate about marriage and marriage, again, as a symbolic center of the family. So we can see, for example, in the UK, following many other countries, which we just saw on that slide with the really small font, the UK last year instituted its same-sex marriage policy. Scotland did the same. So this is actually just Britain and Wales. Scotland did the same last winter. And then we had the very first same-sex marriage celebration, not civil partnership registrations, in the UK in March. And here's part of this wave that Kelly was just talking about, a global wave of starting to see, to a certain extent, a pluralization of marriage. So states are certainly, just like they were 100 years ago, states are getting involved in marriage and the family, but in a really, really different way. They're making it more accessible to different groups. So forced marriage doesn't seem to go with that, but this is an interesting question. So on the one hand, we see that the freedom to choose is becoming really important. So hence Theresa May's comment about forced marriage is against the standard. But on the other hand, here's state intervention saying that marriage is supposed to look like one thing. It's supposed to be the way for families to take form. And this in a way relates to what Kelly was discussing just a minute ago, that marriage seems to have become a norm to the exclusion of others. So how do we pluralize marriage? Is forced marriage not allowed, but same-sex marriage is, or other sorts of standards? So there's a broader debate that this is fitting into, and this broader debate is about the law. It's about what states do. How do states get involved in the family? And what I'd like to suggest is that if we think back historically, if we think back to how marriage has been dealt with in the past, we can see that it's never really been a standard. It's always been complex, and states have been interfering in different ways. Laws have been involved in marriage in different ways over time, and marriage has never been static. And this idea of the freedom to choose is, in a way, a current iteration of this debate and a current iteration of thinking about what marriage is supposed to look like and how society is supposed to look. And so what I'd like to suggest is, in a way, that marriage has been tinkered with constantly over time and currently in recent discussions, and history can tell us a lot about what this means. And in particular, it can tell us that regulation embodies certain cultural norms. So whether you have a same-sex marriage policy or a civil registration policy, or whether you don't, whether you have a forced marriage, a ban on it, or whether it's allowed, indicates certain cultural norms. And in the case of recent debates in Britain, I would suggest that these cultural norms are about man and wife, and they're very much based on a Christian understanding of marriage as a sacrament. And this understanding goes back in the past to many marriage laws over the last many hundred years. And what's very interesting here, and Kelly was hinting at this in her talk, was that pluralization is not necessarily something that we see in some of the earlier debates about same-sex marriage. It's very much man and wife, but instead man and man, or wife and wife. And it's a set norm from the past, and it's a very static norm which has been sort of reinvented in a really creative way. So to a certain extent, this is this Christian understanding of marriage as a sacrament and the family and two individuals consenting to be with each other. But in another sense, it's also something which we can look back in time again to the 18th century, to the Enlightenment, to this idea that people are rational and free to choose who they want to be. But what's interesting is that there is this historical element of the state getting involved in the family, and in particular in marriage as something which seems symbolically very important. And so the symbolic politics of marriage is something that's not only unique to the 1980s and the 1990s, but we can see in 1870s Germany, and we can certainly see much, much earlier. So I'd like to talk about how marriage has been tinkered with and how the family has been tinkered with by the state and regulated because of certain ideas about cultural norms over many hundreds of years by looking at 3 case studies. I realize that we can't look at everything and it would be really boring to do so. So I'm going to talk today about civil marriage, about polygamy, and about mixed marriage. So marriage between people of different confessions or different ethnicities. And these are 3 ways that I think are really interesting for us here today to think about how marriage has been constructed as a social and cultural norm and how that norm has changed over time in different historical contexts. So the first thing that I think is a really interesting way to look at the role of the state and marriage and the construction of marriage as something symbolic is civil marriage. So if we think about recent British discussions about same-sex partnerships and civil registration, we can actually think back already to possibly Henry VIII. And I know this sounds really strange, but Henry VIII was convinced, after going through many, many wives, that he should be in charge of his romantic future, as well as his reproductive future. He's probably not the model to follow. So beheading's not necessarily the way forward in terms of romantic relationships. But nonetheless, he had this idea, at least he prioritized this idea in public. We don't know if he really believed in it passionately, but he prioritized the idea that he should be able to choose who he wanted to be with. And the idea here was that, again, it's a sort of Christian understanding of marriage as a sacrament. It's two individuals who are consenting. It's this sort of norm, which we can see going back to the Middle Ages, and we can see taken up in various policies. And in fact, that's exactly what he does. He changes the law, makes it much easier to divorce, so that two individuals can be together if they chose, without having to go to the extreme of beheading the partner to find a new one. But this idea of two individuals consenting wasn't necessarily something that was seen as enough in Britain, certainly. And over time, this idea that marriage is something about the community starts to take hold, and it becomes more important and it comes to the forefront. And by the 18th century, there's a real backlash against couples who are just following their hearts, not unlike Henry, and getting married. And there's a lot of concern because it seems that there's a risk that people might get trapped in bad relationships. Maybe somebody would marry someone, and then the spouse could go off and marry another person, and because marriage could be done essentially in private, it was very difficult to tell who was married to whom, whether the marriages were legitimate, whether the children born out of them were legitimate, etc. And so by the 18th century, after a lot of debate about marriage being something communal and public, there's a crackdown on marriage, which is done just as a consensual act between two people who loved each other or who wanted to be together. And that was Lord Hardwicke's Act of 1753. And I know this sounds really trite and really boring, but it was interesting because it meant that marriage became automatically overnight a public good. It was seen to be something which was communal, that the state had a vested interest in making it public. It didn't want people getting married secretly. And what we start to see is in the late 18th century, country after country starts to interfere in marriage with new policies. Marriage isn't something which is just done between two couples who say, I marry you or I consent in private. It wasn't necessarily something that was just done in the church. States started to regulate marriage over time in a way not dissimilar to what we see with Kelly's slide of the S-curve of this global revolution of same-sex registration and same-sex marriage. We start to see in a way an S-curve of civil marriage in the late 18th into the 19th century across the globe. You can see it to a certain extent with Lord Hardwicke's Act, which wasn't really on civil marriage, but sort of related, but especially from the French Revolution, that states said the family is ours, it's in our domain, and we're going to define who can marry whom, what marriage means, and how marriages can be broken apart. And so we can see this to a certain extent in France in the Revolution. There are anti-clerical tones here as well, so state trying to take marriage out of the hands of the church. But there are other ideas at play as well. So of course, in France, the Enlightenment is informing ideas about marriage as something which is rational. Two people are rationally choosing to be together, and it's for the state to watch over this and not necessarily to happen in private or just through the church. And so again, we can see this all over the world. These are just a few indicative cases, but for example, South America has a boom in civil marriage in the late 19th century, much of Europe in the early 19th century, and we can start to see this in the 20th century in a variety of other cases. For example, in Turkey, after it's created as a new country from the Ottoman Empire, and certain Eastern European states in the 1950s. So it really takes off in an interesting way. And what's interesting for us here is that civil marriage is a way that a state starts to identify that marriage is a public good, but also defines who can marry whom and how marriage takes form in society. So this is in a way the prehistory to what Kelly was discussing, but it also indicates to us how marriage has been understood and the sort of cultural norms that are behind it. But there's another example which I think is really meaningful for us to think about historically, about how marriage and the family have been tinkered with over time, and how they're not enduring entities that are that have the same shape and same form over time, and how they are policed in different ways and regulated in different ways according to different historical contexts. And I think a really good example for us to think about is mixed marriage, sometimes called miscegenation. That's a very problematic term. And what's interesting for us here is exactly the fact that mixed marriage has been policed in so many different ways over time in different contexts. So this idea of who can marry whom, is it legitimate for a marriage between a Jew and a Christian in the case of 1930s Germany, where mixed marriage is outlawed in 1935. who can marry whom. In the 1870s, the case is exactly the opposite, interestingly. So in Germany, here's a little propaganda pamphlet from 1877 against Catholic and Protestant mixed marriages. So part of the movement for civil marriage in the 19th century was the idea that it becomes a state good. Anybody could marry anybody. You didn't have to get married in church, so there was no risk that your church would say, I don't want a Catholic to marry a Protestant or a Jew or what have you, because it's a state good. So in principle, anybody can marry anybody. But here we start to see different understandings about who should marry whom. Here's a private view through a propaganda pamphlet. But here in the 1930s and 1935, under National Socialism, we see that the state steps in and actually bans mixed marriage. So again, the idea of who can marry whom and what the family should look like is constantly shifting based on historical context. And again, the idea of mixed marriage it really takes off over the 20th century as a problem area. So we can see a number of policies which expressly forbid it. So in the United States in the late 19th century, and this is finally overturned in the famous Supreme Court case, Loving versus Virginia, which finally got rid of bans on mixed marriage in the US. But there are certain other examples across the 20th century where you can see that this is a problem area that's debated, and it shows particular understandings of the family and who constitutes the family, what the family means to society. So another example is, of course, South Africa's ban on mixed marriage in 1949, which was finally overturned in 1985. And the final example, which comes to the forefront really clearly if we think about how states and families coincide and how the family is often policed by the state, is of course polygamy, which Kelly mentioned very briefly in her talk. And so polygamy, again, in the 19th century, comes to the forefront of popular imagination and also to a certain extent of the law because of imperial expansion. So as empires like the British Empire, the French Empire are starting to expand all over the world, there's in a way a public outcry and a panic about polygamy on the one hand, when it involves Europeans marrying into polygamous relationships, because polygamy seems to go against Christianity, it seems to go against this moral norm, which is embodied in European marriage laws. But on the other hand, polygamy is seen to be completely legitimate in the empire overseas, as long as it doesn't involve Europeans. So for example, in the British Empire, there's something used called personal law, which means that if you are Muslim or Hindu, if you're Sikh, whatever your religion is, you follow the family practices and the marital practices of where you're from. If you're overseas in the empire, if you're back in Britain, or if you're a British person living in India, then you still have to follow your own practice. So again, this idea of marriage as something which is policed in certain ways according to certain cultural norms comes to the forefront really clearly. So similarly in Germany, polygamy is seen to be legitimate in German colonies in East Africa and West Africa, but if it involves German women in particular, where there are a number of cases in the early 20th century, there's a huge public outcry. So again, we can see that the family is constantly being tinkered with according to certain ideas of what's correct. So I started off by talking about Theresa May's discussion of the freedom to choose. And so earlier this summer, we saw that this idea of the freedom to choose any kind of family relationship, any marital relation, seems to be at the forefront of British thinking in 2014. But to what extent is this really the case? And moreover, if we look at the long history of marriage, has there really ever been a freedom to choose? Has marriage as the symbolic heart of the family always been tinkered with in certain ways by particular states and particular communities? So these are a number of questions to think about. So first, the family, in a way, has been part of a number of different culture wars between different confessions, between church and state, between different countries even. But also, ideas about the liberalization of marriage often reflect, or always really reflect, particular context, historical context, and these change over time, but different context also as well. And we can think about how ideas of the family are phrased. So often we can see that things are phrased in terms of cultural norms or national norms, but what do these mean? And why do different actors refer to things as being culturally characteristic or nationally or religiously characteristic? What does that mean, and why is that the case? And then finally, and Robert will certainly pick up on this, debate about civil partnerships rather than marriage is part of this long-standing history that we see. These questions about who can marry whom, what marriage means, what the state does with marriage, whether it involves itself, whether it doesn't. So all of these really big questions come to the forefront in the past, but certainly in 2014, when we think about these current debates, we can see that this is part of an ongoing history. Thank you.
Thanks, Julia. That was a great survey, and we're all left with this amazingly fluid and sort of problematic, in a sense of family policy, and just what a kind of powerful political, civic, and spiritual institution marriage is. That it's at the centre of, in a way, the relationship between the citizen and the state. So, Robert, I'm going to turn to you now. Do you want to go up to the lectern, or are you happy to speak from here?
I might as well go up there. Yeah,
okay,
sure.
So Robert Wintermute, thank you.
So to link to, was it Julia just went? Yes. Julia's presentation, actually, Loving versus Virginia is a very good link. And just a footnote there, Loving versus Virginia was a unanimous decision of the US Supreme Court. But if you go back to 1948, you can read a decision of the Supreme Court of California on different race marriage, which was a 4-3 decision called, it has different names, but Perez versus Sharp is one of the names. And the dissenting judgment is just fascinating reading. I included in my materials for human rights law. So you have judges quoting scientific studies showing that mixed marriages produce inferior stock, and citing South Africa as a good example of keeping the races separate. So it's for the ancestor or the descendants of those judges, it's quite embarrassing reading today. They were certainly on the wrong side of history. But that sort of introduces my perspective on this debate, which is really the equality perspective, equality without discrimination, not based on race, but based on sexual orientation. So the lesbian and gay community is a minority and doesn't really get to decide what the rules are for marriage, the content of the institution, the different possibilities. It's more a question of saying whatever is there, whatever the heterosexual majority decides, we want in. So I moved from Canada by way of New York, where I worked as a lawyer, to Oxford to do my PhD in 1987. So I arrived in England in time for Section 28. So I've witnessed the history from 1987 to 2013. So 1988, Section 28 has already been mentioned, possibly or not?
No.
No, okay. So Local Government Act 1988. Well, what you had in the 1980s was a conflict between Margaret Thatcher's Conservative government and Labour-controlled local authorities, which were very progressive. So they were way ahead of the center and majority opinion. They were introducing the idea of positive images of lesbian and gay people. Apparently there was one copy of a book called Jenny Lives with Eric and Martin that was included in a resource center for teachers just in case there was a child living with the same-sex couple as the child's parents. And that was then portrayed as the set text for 6-year-olds across England, sort of mandatory reading. And that's what led to Section 28 of the Local Government Act, which prohibited the teaching in maintained schools of the acceptability of homosexuality as a pretended family relationship. Okay, just pause for a moment to take that in. Okay, that was the starting point. Well, not really the starting point. The starting point in England and Wales for same-sex couples consisting of 2 men was the death penalty, repealed in 1861, and then life imprisonment, repealed in 1967. So I suppose being called a pretended family is an improvement. But there wasn't a lot of respect for same-sex couples back in 1988. So it was a long struggle. The 2 battles of the 1990s were the equal age of consent, which took until 2000 to be achieved with the assistance of the European Commission of Human Rights, and equal access in employment, and the test case was lesbian and gay members of the armed forces, and there was a judgment of the European Court of Human Rights in September 1999. And it's very interesting to see the difference in the government response. Today we have a Conservative Party in the coalition that hates the European Court of Human Rights, has just promised to leave the system, or at least make the judgments no longer binding if it wins the next election. Back in September 1999, the day the European Court of Human Rights said it was well, they didn't say it was discriminating, but they said it was a violation of the convention to exclude lesbian and gay members of the armed forces. The government suspended the policy the same day. And about 3 to 4 months later, they formally repealed it or abolished it. So, yeah, it was quite a different respect for the European Convention on Human Rights then. So, the LGBT community generally has been a great beneficiary of the European Convention on Human Rights and the Human Rights Act, which was passed to give effect to it. So I'm going off on a little political tangent here. If you excuse me, I'll get back on topic. It's just that you now have a Conservative Party that's going to go to the lesbian and gay community and say, please vote for us because we introduced same-sex marriage, and you should be very grateful. And there was some polling evidence in December that this was working. So I wrote a comment for Pink News saying basically, don't be seduced by this. This party is the nasty party again, as they were described in 2002. They want to take your human rights away now. So in any case, yeah, armed forces, age of consent, and then suddenly things went at warp speed in terms of legal reform. In 2003, we got the Anti-Discrimination Regulations as a result of an EU directive, and 2005, December 2005, the Civil Partnership Act comes into force, as does the part of the Adoption and Children Act 2002, allowing same-sex couples to adopt children jointly. So, yeah, from an armed forces ban unequal age of consent as of August 99, you're talking about a 6-year period. So it was incredible progress. Now, when this civil partnership bill was being proposed, I raised the possibility of going straight to marriage. Let's just skip this step. The Netherlands, Belgium, Canada, Massachusetts, the Supreme Court of Massachusetts decision had just come out. But the political reality was the government wanted to get the Church of England on side. So this was to avoid all the fuss we had last year about quadruple locks. In particular, civil partnership was drafted in a way that it didn't require any consummations, any sexual activity. So the question of lesbian and gay priests in the Church of England was, the idea of them having sex was carefully avoided. So they could enter into a civil partnership and claim to be celibate. So that's the way politics works. In fact, very few countries have gone straight to marriage. I spoke at a conference on same-sex marriage in Rome at the end of May, and I was asked by a senator, an openly gay senator, so what should we do? And I said, well, if you look at Europe, where not a single court anywhere, unlike in the US, Canada, South Africa, Mexico, a few other places, has been willing to strike down a law excluding same-sex couples from marriage. In Europe, the only way is to go through Parliament. Parliament is about compromise, incremental change, and so what usually works best is to separate the question of giving equal rights for the couple from the name marriage. And that's what we did in the UK, and that's what they'll try in Italy as well. So, and in some countries it's a bit more complicated because their equivalent of civil partnership does not cover adoption or access to donor insemination. But we had dealt with all those issues adoption in the 2002 Act, donor insemination, surrogacy was all tidied up in 2008. So it really was just a question of the name by the time the 2013 debate came along. So yeah, it happened possibly faster than I would have expected. I mean, less than 10 years between the two acts. I think that came as a surprise. But in my remaining time, I think I'll just refer to the unfinished business, because I'm an anti-discrimination lawyer, and we're not happy until it's all been removed. So there were two issues that came up in Parliament, and I believe Labour proposed amendments, and the government opposed them and said, well, we'll have a review to deal with both of these questions. And a provision for a review was written into the Act. The first one was survivors' pensions for same-sex couples. Now, the government wrote a really mean exception into the law in 2005, just before the Civil Partnership Act came into force, which says that a pension scheme does not have to give credit for contributions to a pension scheme in the case of a same-sex couple. They don't have to give credit for contributions before the 5th of December 2005, before the Act came into force. So if you joined a pension scheme in 1964, worked for 40 years, made contributions, same contributions as everyone else, and you retired in 2004, your pension scheme is legally entitled to give you a pension to your surviving partner of 0, surviving civil partner. That is the law. Now, fortunately, the majority of pension schemes don't do this, especially the public sector ones, but there are many private sector ones that do. And there's a case now pending, it's called Walker versus Innospec. It's going to be heard in the Court of Appeal in February. And in that case, the difference in pension, if Mr. Walker has his male civil partner, if he had a female spouse, the surviving pension after he dies, assuming he dies before the spouse, would be £41,000 a year. The way it stands now, if he dies before his male civil partner will get £500 per year. And that is perfectly legal. It's written into the Equality Act 2010. But there's a very strong argument that it's contrary to EU law, which does not permit this exception. I've just sent off a comment to the Industrial Law Journal, which will come out in December, which I hope will help persuade the Court of Appeal to either reverse the decision or refer the case to the Court of Justice of the European Union in Luxembourg. So I'm optimistic that eventually it will be recognized that that mean exception is contrary to EU law and will be reversed. As far as I know, I'm a member of the university's superannuation scheme, and it appears not to discriminate in any way. Marriages, civil partnerships are treated equally, full backdating of contributions. So it doesn't affect everyone. Now, the other piece of unfinished business relates to civil partnerships. To be perfectly honest, the Stonewall group was not initially in favor of equal access to marriage for same-sex couples. I recall having dinner with Ben Summerskill in around 2004, 2005, and his position was, well, everyone will call it marriage, and that's good enough. And I thought, well, no, it's not the same. It's got a different name, and certainly it won't travel well outside the country. There will be countries that will say, what is this, a civil partnership? We don't have this. We only recognize marriage, etc. So it took a long time for Stonewall to be persuaded. They did change their position around October 2010, but they took position that they wanted marriage for same-sex couples, and they wanted to preserve civil partnership as something, I'd have to check the wording again from their website, something like special and unique. So they wanted civil partnership for same-sex couples, and they took no position on whether it should be extended to different-sex couples. Meanwhile, about December 2009, I think it was, Peter Tatchell went to Islington Town Hall with a different-sex couple. If I get the, I think Catherine Dolan, Tom Wilkinson, if I've got the names right now. He's an actor. Sorry. Anyways. And they'd asked for a civil partnership and were told, no, you're the wrong sexual orientation. You have to be a same-sex couple to get one. And Peter Tatchell was going to try to start a case in the European Court of Human Rights at that time. And I said, so I emailed him and I said, Peter, this definitely will not work. They will get zero sympathy in the European Court of Human Rights. You have to challenge the system as a whole. So we ended up organizing a case with 4 same-sex couples. All of them went to the town hall and asked for a marriage and were told no. 4 different sex couples went and asked for civil partnership. They were told no. The 8 couples together, we had a, the name of the campaign was the Equal Love Campaign. So if you go to equallove.org.uk, there are various videos and photos. 2nd of February 2011, we had an event where we actually took the application to the European Court of Human Rights and put it in the letterbox near Parliament, one of the boxes there. We tried to arrange a faxing ceremony and it didn't work out. But anyways, the application went off to the court, and we like to think that it added to the pressure on the government to change the law, because it would have been very embarrassing for them to have to explain the system of segregation of couples. Now, when they did change the law, they only responded to half of the application. So they changed the law for the same-sex couples. In August 2013, the month after the act was passed, I received a letter from the European Court of Human Rights asking whether the 8 applicants wished to maintain their application. So I replied, well, in the case of the same-sex couples, yes, because the law isn't in force yet, and there's this ongoing issue with regard to pensions. And I didn't put in that the law hasn't changed in Northern Ireland, but I was trying to think up an argument that, well, maybe they might move to Northern Ireland in the future, but they all lived in England and Wales, so it was hard to make that argument. But on the other side of the case, I said for the different sex couples, the law has not changed, so they wish to maintain their application. And in December 2013, the court declared the application inadmissible, giving no reasons. Just you get a 1-page letter. These are really very frustrating letters going to the court for a meeting on the 21st of November, and I'm going to raise this as a matter of procedure. They don't give you the slightest clue as to what was wrong with your application. Now, to excuse the court, I can think of one very technical reason, which was when the case started and when it ended, there was only one choice per couple at the town hall. It was either marriage or civil partnership. But that changed on the 29th of March 2014, and it is now, and then the law has been the same ever since. So same-sex couple goes to the town hall, and they're asked to sit down, and the registrar comes along with a menu, and then goes away for a while and comes back and says, can I take your order? Will that be a marriage or a civil partnership? Okay, and if a different sex couple goes to the town hall, they can be treated horribly. And they will be told, well, it's marriage or nothing. Take it or leave it. And that is unacceptable. That is what we call direct discrimination based on sexual orientation. The only justification for it would be some kind of positive action, positive discrimination, compensation to same-sex couples. Well, how does that compensate same-sex couples? So we get to feel superior for 100 years and flaunt our civil partnership certificates. We're not talking about access to employment where there's underrepresentation, et cetera. There's absolutely no justification for it. And there are 2 judgments of the European Court of Human Rights that apply. One is called Valianatos versus Greece. It says if you create something other than marriage, it must be open to all couples. In that case, Greece created something called a common life pact for different sex couples only. So it was really adding insult to injury in Greece, because the score went from 1 to 0 to 2 to 0. So different sex couples had 2 choices and same sex still none. So that was found to be a violation of the convention. Then we have another case called Konstantin Markov versus Russia, which was about a father in the Russian armed forces who wanted paternity leave to take care of his children, or let's call it parental leave. And they said, no, it's only for women. And so he won his case in the European Court of Human Rights. The court said, no, looking at the trend in Europe, etc., parental leave needs, especially where there is a distinction between the leave that's for a woman to recover physically from giving birth. That can be reserved for women, but we were talking about a period of 3 years. So a period to raise a young child must be made available both equally to mothers and fathers. So putting those two cases together, I think it's just an open and shut case. And unfortunately, the outcome of the government's review published in June said they were not going to change civil partnership and they were going to leave things the way they are. Now, to my knowledge, Britain is the only country in the world that gives more rights to same-sex couples than different-sex couples. There are possibly 2 states where this anomaly exists in the US, California and New Jersey, but it's because the court introduced marriage equality and the legislature introduced separate but equal institutions, and the 2 have not been reconciled. But I'm pretty sure the UK is the only country in the world where the legislature or parliament has deliberately created this asymmetry. So the government eventually will have to choose. I hope that there will soon be a case either in the UK courts or the European Court of Human Rights. And the choice they'll have to make is between extending civil partnership to different sex couples, therefore to all, or abolishing it. And if you look at the historical trend, unfortunately, we need to buck that trend, because the trend has been where a country introduces a new form of registration only for same-sex couples and later allows them to marry, it abolishes the new institution. This has happened in Iceland, Norway, Sweden, Denmark, Connecticut, Vermont, New Hampshire, multiple places. The idea seems to be that somehow this is like a rat-infested house. It's kind of tainted because there was a discriminatory purpose in creating this new institution in the beginning. But I would say, no, there's nothing wrong with the house. It's perfectly habitable. Just take off the sign on the front door that says same-sex couples only. And there are many examples of countries now that have introduced a new institution for all couples from the start. The first one in Europe was the Netherlands when they introduced registered partnership. In 1997, it was for all couples. So step 1 is for the government to realize that this is discrimination violating the European Convention, assuming we haven't left the convention. And then they have to make the choice. And then it will be for the voices of different sex couples to be heard and to say, we want choice. And I see no argument against it. David Cameron's argument against it, which came out, there was a piece in the Sunday Times in March or April, was that this would be a threat to marriage. Well, the statistics don't bear that out in other countries. I checked for 1 year in the Netherlands in 2009. 88% of different sex couples chose marriage, 12% registered partnership. So, and if it brings some committed couples into a legal institution that's good for them and good for their children, which they would not otherwise be in because they simply refuse to enter the, for them, historically tainted institution of marriage, it's good for society. So I'm hopeful that the outcome will be a choice for all couples of marriage and civil partnership. And the very last thing I will add is the really neglected area in the UK, or at least England and Wales, is cohabitation without registering at all. because the problem is that you can have 45 types of registration. There will be some couples that will just never get around to it, or you'll have one partner who wants to register and the other doesn't. And they can live together for many years, one of them dies, or they split up, and suddenly they have no legal rights. Now, England and Wales is really behind in this area. There's far greater recognition of cohabiting couples in the Netherlands, in Canada, Australia, New Zealand, South Africa, lots of places. Not so much the US, where it tends to be marriage or nothing. But, so that's where we should end up. Every couple has a choice: cohabitation, civil partnership, marriage, and the rights should be more or less the same. Thank you.
Thank you very much, Robert, and we must leave it there. We've had a great, wide-ranging discussion, and I think it's really suggested to us by this kind of broad survey just how fluid and multiple and plural are the models by which human relationships get regulated. So I'd like to thank our speakers. Thank you.